my name is Spencer Ford, Certified Financial Planner with Conservative Financial Solutions, and I'm happy to have Ed Bender here with me today, attorney at law with Wood & Lamping, and actually the chair of the estate planning, trust, and wealth transfer sector of
Right.
Wood & Lamping, right? So,
That's correct.
and we're just here to have a conversation today, and so before we get too deep in that conversation, I just want to say that that's exactly what we're having. We're having a conversation, so please don't take this as a recommendation for your specific situation. We both would encourage you to consult with your financial professional, your tax professional, your legal professional before making any decisions. Every situation is unique. State laws differ from state to state, so you want to make sure you're working with somebody who understands your situation, your state laws. So please don't take this as any specific financial advice, legal advice, tax advice today. We just want to have a conversation and hopefully open your eyes to some estate planning stuff, maybe give you some ideas that you can then take back and have a conversation with your legal professional, financial or tax professional. So anything that you need to add to that, Ed? Is
I
that?
think that's well said, Spencer. Thank you.
Yeah,
We're
so
just going to have a general conversation about basic estate planning topics.
exactly.
Right.
So before we get, or as an introduction to you, if you wouldn't mind, maybe just talk a little about how maybe you got interested in law,
Okay.
your time at Wood & Lamping, and then just your area of specialty.
Sure. I've been practicing law now for 27 years. For the past 22 years at Wood & Lamping. And I primarily practice in the areas of probate and estate planning law, tax law, real estate law. I advise individuals, families, small businesses on all of those topics. So that's what I've been doing for the past, again, 27 years. And like I said, for the past 22 years here at Wood & Lamping, where we have 4 or 5 different departments, I guess 5, here in the firm, and I am head of the probate and estate planning department. So I have 5 or so of my colleagues that practice primarily in the areas of probate and estate planning law. We have 2 excellent probate paralegals as well, who help us with the probate, estate, and trust administration cases. So we advise folks on their planning. We advise people if they're in the middle of an estate or trust administration. That can be if they're in the role of the executor for the estate. We give them legal advice on how to comply with the trust code, the probate code, the Internal Revenue Code. If they're the trustee of a trust, we advise them on how to comply with the Ohio Trust Code and everything else. So very often we get clients who are a beneficiary of an estate or trust. Someone else is actually handling the estate or trust, but they're a beneficiary, and they have questions about their rights as a beneficiary, so we represent them as well.
Yeah.
So we're busy.
Good,
Yeah.
good. And in the line of work that we do, and oftentimes we partner together on that, but we have families that come in who need estate planning help. Or I would say probably 9 out of the 10 families I meet with, they either don't have their legal documents in order or they're extremely old. So just real quick, what would be some of those basic estate planning documents that you would pretty much recommend that everyone at least needs to take a look at having?
Sure. So start with a will. Everyone needs to have a will. You're over the age of 18, you're competent, you need to have a will. Okay? A will is a document that governs the disposition of your probate assets when you die. All right? So that's kind of a loaded term. What's a probate asset?
That was going to be my follow-up question.
There you go. So a probate asset is an asset that is in the name of the deceased person alone at the time of death. Okay? So, for example, it's a bank account and it's titled just in the name of John Jones, period. That's a probate asset. It doesn't have a joint owner on the asset. It doesn't have a beneficiary designated on the asset. It's not in a trust. Okay, that's a probate asset. So when John Jones dies, we need to know who owns the asset now. All right, and the law of all 50 states and many foreign countries, by the way, says, well, the owner of that asset is now the person or persons who are named in the person's will. If they have a will. If they don't have a will, then all the states have laws on the books that state where's the property going to go because the person had no will. All right?
Okay.
So that's a probate asset. So everyone needs a will, so that you state who you want that asset to go to, who you want your estate to go to. Otherwise, the state law is going to control where it goes. Now these days, very often when a person dies, there are no probate assets because the person had a joint owner on every single asset that they had. There was a car, their real estate, and that asset passes to the surviving joint owner. Very often people put beneficiaries on their life insurance, their 401k, their IRA accounts. Those assets pass directly to the beneficiary named.
Yeah.
You don't need a will to govern the disposition of that because you've got a beneficiary. Or they've set up a revocable living trust and they put the asset in the name of that trust. Okay? That's very common, although you don't want to do that with retirement assets. We'll come back to that.
Yeah.
So that's why you need a will, in case there's a probate asset out there at the time of death. Next most common document that a person should have is a durable power of attorney. Okay? So this is a document in which you're stating the name of some person to handle your financial assets. If you're alive, but you're incompetent, you're in the hospital for a period of time, and you're unable to access your funds to pay your bills as the bills keep coming while you're in the hospital and in a coma, for example. So that power of attorney document is critical. You need to have it in place, drawn up, signed, and it should name a primary person to be your what's called the attorney in fact. And you should also have a backup person named in there in case the first person you name is unable to act for you.
Yeah, a lot of times I'll tell spouses, like a lot of times spouses travel together, right? So God forbid something happens to two of you at the same time.
Right.
That's a really great example
Right.
of why you want a backup named up. Plus also, someone who you appoint as your durable power of attorney, they can decline to...
Correct.
Yeah, so
Right.
it makes perfect sense.
Yep. You know, and very often clients, they can't come up with another person. That's okay. You know, but at least name one. But yeah, I always encourage folks to come up with at least one other person as a backup. Okay, it's not going to cost you any more money for me to put another clause in there
Yeah.
that says this person shall serve as the backup. Okay, so covered a will, general durable power of attorney, healthcare power of attorney. I think is the third most critical document that you should have. This is a document in which you name someone to make healthcare decisions for you if you are incompetent. You're unable to respond, you know, on your own. For example, you're in the hospital, and again, maybe you're in a coma or something like that, and the hospital, the doctors, they need to get informed consent from you to operate on you, and you can't respond. So if you have that healthcare power of attorney in place, that's a good thing. You know, if typically an emergency room situation, you know, there's someone from the family there who can respond for you, maybe a spouse or a close family member. If not, then it would be nice to have a healthcare power of attorney. And you typically sign that. In Ohio, it's either in front of two witnesses or a notary. We recommend that people send at least a copy of that to their primary care physician after they've done it, so that it's in the file of the primary care physician. It can be easily transferred over to the hospital emergency room, you know, on request. So that's a critical document.
Yeah.
Will, general power of attorney, healthcare power of attorney. I would say the other critical thing really these days, it's not necessarily a document, but it's double check, triple check your beneficiary designations on everything.
Yeah.
Again, your retirement accounts, your 401k, your IRA, do you have beneficiaries designated who are alive?
Yeah.
Okay. Primary and secondary beneficiary designation forms. Make sure those are all filled out, up to date. We have lots of cases in the office where, people come to us, someone in the family has died, it's a life insurance policy. We contact the life insurance company and, there's only one beneficiary who was ever named and that person is predeceased, the owner. So now we have to probate the policy. So that's true with life insurance, again, 401k, IRA.
Yeah, and in my experience too, you never want to end up in the situation where you're sitting in the middle of a review. I've had this happen with a family, and you get to the life insurance, you're checking beneficiaries, because we always check beneficiaries, and we find out that the ex-spouse is still the beneficiary on the life insurance policy, which is, an interesting space to be in when you're in the middle of a meeting with a family.
Right, exactly. So there's some details in I can tell you Ohio law, for example. I'm pretty sure Indiana is the same way too. There's state law on the books that says the ex-spouse is automatically revoked as a beneficiary in most cases on that life insurance policy. So, then if there's no one named secondarily, you've got a probate asset. Okay, so it's not a document, it's not one document that we're talking about there that's a critical document, but it could be a lot of beneficiary forms. Those are the four most critical things.
Yeah. So I just a couple questions, just going back a little bit. So when we're talking about wills, if you die without a will, I believe that's called dying intestate. Is that correct? And then basically what the court then will appoint an administrator of your estate. And
right.
So just about that process, so I would say you want a will because then you're selecting the executor that you want to be over it, right?
That's right.
But in a typical situation, if the court's going to appoint an administrator, is there any guidelines as to who that is, or how does that come about?
There's a list of people who have priority to be the administrator of your estate without a will. And most state laws will indicate, if it's a spouse, if the person who has died is survived by a spouse, the spouse has priority. Adult children would be next in line. Yeah, so there's a listing. Gets complicated sometimes if, the person, Ohio, for example, requires administrators on an intestate estate to be residents of the state of Ohio.
Oh.
Yeah. So that gets to be a little bit of a problem. If the closest family member is not a resident of Ohio, it can be a problem. It can be a problem. Now there's some details there that we don't have time to get into. Because some Ohio laws, anyway, it's complicated.
I gotcha. Well, the biggest, it's avoidable, right? It's completely avoidable. Just have a will, name your executor. That's going to be the person that you want it to be, right? So, and then
bonding requirement also comes in too. If there's no will, the person who applies to be your administrator in Ohio, they have to post a bond. It's like an insurance policy. Yeah. The bond by law is equal to, you have to post a bond in an amount that is double the amount of the personal property in the estate. So it can get expensive. If there's $100,000 in bank accounts, stocks, bonds, mutual funds, they have to post a $200,000 bond to become the administrator. So is that person, can they get a bond? They're going to do a credit check for the person who's applying to be the administrator because they have to get a bond. We very often run into problems there. You can't get a bond, you can't be the administrator.
So basically bottom line in the story, while you're alive, get your will taken care of.
Sign a will, right.
And then the other thing that, just going back to the general durable power of attorney, I don't know if this is a good example or not, you can tell me, but a lot of times what I'll tell families when I'm sitting down with this, if I have a married couple, right, and I say, God forbid one of you is incapacitated, right, like if it's the husband in this situation, I'll tell the wife, hey, you can't call that 401k company and request assets, because the first thing that they're going to do is they're going to say, well, do you have a power of attorney? They're not.
Right.
So if you're in a situation in which, hey, you're in a dire situation, you need help right now, you're a spouse trying to gather funds, but if that's in the husband's name, you need that durable power of attorney now. And it might be that a court will appoint you as one, but you don't want to have to wait on that, right?
The alternative is a guardianship. Okay, so if there's no durable power of attorney and the incapacity goes on and on and on and on, weeks, months, it's a coma situation or something like that, or the person is permanently rendered incompetent, the alternative then is someone's going to have to go to the probate court and apply to be your guardian. Okay, so there's a guardianship of the estate of an incompetent adult person. That's what you'd have to have. So someone had to go to probate court, apply to be your guardian. Again, the laws of most states are that person needs to be a resident of the state. If the guardianship's in Ohio, they need to be an Ohio resident. And that can be a very cumbersome and costly process. All avoidable if you would simply sign a durable power of attorney.
Yeah, absolutely. And then one thing that we didn't touch on, but I just had a question about, would be living wills.
Okay.
I often encourage families that they want to have a living will. The way I explain that is, when you have a living will, it's what you want done in those hard and fast moments, right?
Right.
In terms of your care, if you're incapacitated. And the way I describe that to families is it's now you have made decisions for yourself as opposed to someone making decisions for you. So it can take the guilt out of the situation a little bit, right? So
Right. That's exactly what
any
living
comments?
will. Right. Living will is a document in which you're stating to the hospital, to the doctors, that they have the authority to, if you have been declared to be brain dead, okay, in Ohio, specific definition, total loss of cerebral cortical functioning. 2 doctors certify that you're brain dead. And they're saying, even though you're on these life-sustaining equipment, if they turn everything off, they're verifying that if you turn everything off within a short period of time, after they do that, you're going to expire naturally. If all those certifications are in place by 2 doctors, and if you've signed a living will, then they have the authority to do that without having to go to the family to ask them, okay? That's what that document is there for. Now, are they still going to ask the family in those situations? I think 9 times out of 10, of course they are. They're still going to ask the family. But look, a lot of people don't, when they're asked, do we have your permission to turn everything off? Who wants to be the person who's forever remembered as,
Yeah, exactly.
I gave the go-ahead to turn everything off. No one wants that. Or they're emotionally distraught at the time. They just can't make a decision.
Yeah.
So that's what the living will is for. It takes the burden of that decision off that family member. So yeah, that should be signed as well. Now, again, a minimum though, healthcare power of attorney. Make sure there is someone designated. But if the healthcare power of attorney, again, is distraught and doesn't want to do that.
Just because you're the appointed person doesn't make the decision any easier, right?
Correct,
Yeah.
correct. You don't have to. You don't have to make that particular decision either.
Yeah.
You can punt.
Yeah.
To put it in football terms. You just can say, no thanks, I don't want to be the person who gives that answer. And, the hospitals go, well, they do have a living will, and it did say if he's ever or she's ever in this situation, then they can do this, so.
Yeah.
Okay.
So I want to dive into just really one more topic today. And before we dive into that topic, the topics around long-term care, needing long-term care, how you qualify for Medicaid if you're in that type of situation. So just want to say up front here again, we're just having a conversation. We're not giving any specific legal, tax, or financial advice. This has been in the past something that's kind of been debated in different circles, different different ethical circles and things of that nature. So Ed's definitely going to go into everything we do is above board, right? Everything we do is legal, and making sure that our families that we take care of are squared away there. But just want to mention again up front, we're not making any kind of recommendation here today for people to go out and do what the next conversation we're going to talk about. So
Right.
when it comes to somebody needing a long-term care, is before we even talk about Medicaid spend down, though, it's like once you get to that point in time, like you've done a lot of like haven't done planning essentially,
Right.
right? So
Right.
so before we get in, what are some things if there's a high likelihood, there's statistics out there are that a couple age 65 today, there's like a 70% chance that they're going to need some form of long-term care services throughout the course of their lifetime. So knowing that that's the reality of the situation that people are in, what are some pre-planning things people can do if they are anticipating a long-term care need?
Long-term care insurance, use your own funds, or get qualified for Medicaid. Okay, those are the three ways to pay for the high cost of skilled nursing care in a nursing home, okay? Use your own funds, use long-term care insurance, or get qualified for Medicaid, all right? So, very often clients come to us and there's a financial crisis in the family that's going on now or that's imminent because they can see that someone in the family, a spouse or a parent, is going to have to go into a nursing home. And they've been told it's, $9,000 to $10,000 per month. And the spouse, their family member's income is $2,000 or $3,000 per month. And they're going to have to get into the principal of their assets to pay for this. Okay? So is there any other way?
Yeah.
That's the question. Well, first thing we ask them, did you have any long-term care insurance? If they did, hallelujah, that is the best news that we hear, is when the person had the forethought to get that long-term care insurance policy years ago. Then it's all about, hey, contact the company, get the claim running, get those dollars flowing in to help offset the bill from the nursing home. If no long-term care insurance is in place, then the family's typically asking, well, is there any way we can apply for Medicaid? Okay, well, Medicaid is a welfare program, not to be confused with Medicare. Medicare is simply the health insurance everyone gets automatically at age 65 in the United States, okay? And that pays for mostly hospitalization and doctor visits and so forth.
Yeah.
Does not pay for long-term stays in a skilled nursing care facility. It pays for some of it, only a limited period of time. Maximum really of 100 days. Really technical here, details. Medicare will pay for the first 20 days of skilled nursing care in a nursing home. Then days 21 to 100, there's a copay that the person pays. All right. At some point, you're cut off.
Yeah.
The facility, the insurance company will say, you're not going to make a recovery, and we're going to terminate coverage. At that point, again, now you're down to either use your own funds or you get qualified for Medicaid. All right? So complex rules come into play if the Medicaid applicant has a spouse.
Okay.
So maybe we'll come back to that.
Okay.
Let's assume that the Medicaid applicant is single. The Medicaid eligibility rules are very easy to understand for that person as far as the asset limit. It's $2,000. The most they can have in assets is $2,000 before they're eligible for Medicaid. All right? The other question that always comes up early on in our discussions with these clients is, well, why don't we just transfer all the assets to the kids, get down to the 2,000 level by making a gift, and then everything will be fine, right? Wrong, okay, because of what's called a 5-year look-back rule.
Okay.
All right. So again, let's suppose the case is The person is single, who needs skilled nursing care. One of the children goes in to apply for Medicaid at the local Medicaid office in the county where the nursing home is situated. And one of the questions they're going to be asked is, has your parent given away any of their assets within the last 5 years? It's a yes or no question.
Yeah.
Okay? You have to respond truthfully. You're under oath, yes or no. If the answer is yes, they just transferred the assets to the kids, last week, well, then they'll say, okay, we're imputing that back to the Medicaid applicant, and therefore they're over the $2,000 limit. Medicaid application denied, come back later when the assets have been spent down. So that's how it works for a single person. If the person who needs Medicaid, they're in a nursing home, has a spouse, some different rules come into play. For example, if there is a house that they own, the value of the house is not counted towards the Medicaid asset limit. If they have a car, the value of the car is not counted towards the Medicaid asset limit. So certain assets are exempt. Prepaid funeral arrangements, burial plots, those are not counted towards the asset limit. Everything else, essentially what they do, they add everything up. Bank accounts, in most cases, other financial accounts, but there's some big exceptions. They add it all up and essentially divide by 2. It says, let's say all the countable assets come to $500,000. Half of $500,000, they say, the spouse can keep. That's $250,000. But the half that they're allowed to keep is subject to a cap. And the cap is now, I think it's right around $130,000.
Okay.
I should have looked that up.
When we post this,
Yeah.
we'll put it on the
Put the
screen.
numbers,
Yeah,
yeah.
we'll put the actual
The
numbers.
community spouse resource allowance number, it's escaping me at the moment, but I think it's right around 127 or 130,000.
Yeah, it changes every year because it's adjusted for inflation.
Correct,
so, yeah.
correct. So that's the cap on what the spouse can keep on financial assets. They can keep the house, they can keep a car, they can keep half the financial assets subject to a cap. That's how it works.
So in this scenario, though, if they could keep 250, but actually they can only really keep 130 if that's the limit.
Right,
So
right. So it's half. So suppose the countable assets were only 200,000. Half of that is 100,000. Yeah, they can keep the 100,000.
Yeah.
So the spend down would be from 200 down to 100. That's
Okay.
how that works. In the first scenario I gave, the spend down would be from 500 down to the 130.
Yeah.
Okay.
Gotcha.
Yeah. So, what can be done in advance? I think it was your question.
Yeah, that was kind of the original going back. Yeah.
Advanced planning. Well, we talked about the 5-year look-back rule. It's a long time to wait, but if you want to give assets away to your children, or whoever, more than 5 years in advance of when you think you would ever need skilled nursing care, that's the best strategy to follow. All right, because if you give away the assets in August of 2022, and then someone is applying for Medicaid for you in September of 2027, they ask the person, did they give away any of their assets within the last 5 years? Well, in September of 2027, the answer would be no.
Yeah.
Okay, so 5 years have gone by, those gifts don't have to be reported. So that's the most basic gifting strategy. Very frequently, question comes up, well, can I somehow put it in transfer the assets to a trust and somehow have that not counted or as a gift? The answer is no. No, it's still, whatever you transfer out, if it's out of your name, it's either given directly to another person, like a child of your family, or if it's put in a trust. that's a gift. It's still subject to the 5-year look-back period.
Yeah.
The question becomes, what kind of trust at all is ever involved in Medicaid planning? Again, let's go back to a person, single person, widower. They want to make a gift to the family, start the 5-year time clock ticking. There's someone in that family that they want to make a gift to, but then again, they think, well, there's something going on here with this person, okay, this child, that's such that it's not exactly the smartest thing maybe to give them a large amount of money. In those cases, then we start talking about, well, why don't we have one of the children set up a trust to hold the gifted asset? So again, it's out of your name for purposes of starting the 5-year time clock, but it's not sitting in the checking or savings account of this child who maybe has a problem. It's not. It's sitting in a trust account overseen by one of the other family members. So it solves that problem. That's how trusts generally come into play in the Medicaid planning scenario. Now, there are some more complicated trusts, it's true, such as a pooled Medicaid payback trust and these sorts of trusts, that those trusts come into play generally if there's been a person who's already on Medicaid, for example, and there's some sort of windfall that comes to them. They get an inheritance. You know, they're in the nursing home, they're on Medicaid, but they had a sibling who was single. They died, left a big chunk of their money to them, and well, they've got a $2,000 asset limit. So this is a problem.
Yeah.
A problem in the sense that, you know, that's got to be reported to the Medicaid office. It's going to throw them off of Medicaid for a period of time. In those cases, we look at setting up a pooled Medicaid payback trust, which the law says, look, if you transfer it into this trust, pooled Medicaid payback trust, you can draw the money from that during the rest of your life to pay for some things that Medicaid doesn't pay for. Vacations, travel expenses, extras, you know. But the caveat there is, as the name implies, Medicaid payback trust. That means the state gets paid back when you have died. Any assets remaining in that trust belong to the state.
Okay.
To reimburse them for the care that the state has paid for your care all these years, they're supposed to get paid back. That's generally how that works.
So I would say, like, you know, obviously, like when it comes to trust, I mean, there's just a wealth of planning that you can do, even outside of Medicaid. So just maybe we'll have the opportunity to sit down again. Maybe we'll do a deeper dive on trust or something like that, right? Like when it comes to estate planning outside of Medicaid planning, when it comes to estate planning inside of Medicaid planning, just because like I know that there's just an immense of material and then just knowledge you've accumulated over the years that would be really valuable. But just so, and I want to talk about kind of maybe a specific situation with you as a way maybe to get through this, and we'll kind of tie it off there for now. What I will mention though is you're actually doing an event for us on September 15th, our Client Education Forum, and we're actually shooting this ahead of time to provide this as a resource for people who are able to attend this event. So you know, that'll be a good resource for people, and something that we want to say thank you to you, because we get to have these conversations with you as an attorney that we partner with on a frequent basis. So, but as we talk about Medicaid planning, maybe outside of terms of a trust, like let's say, for example, like I have this situation come up a lot, right, where I have a family come in and they're already kind of in the throes of it, essentially. And so it's a spouse situation, a husband or wife. They have $1 million in assets that, you know, outside of their home, outside of vehicles, things of that nature. And they're like, hey, I just had to put my husband in a home. I have $1 million in assets. It's going to cost me $10,000 a month. What can I do to protect the max amount of money I can? Because the answer is you're not going to be able to protect all of it.
Correct.
Right? But what would be some again, not making any specific recommendations to anybody watching this right now, but what would be kind of like, if that was the situation you were in front of, with
Right.
that limited information, what would be some of the steps that we would go through together?
Right, so we would look at, number one, are they interested in making a gift of some kind to family? If that is their main concern, preserving the inheritance for the family. Well, then we are looking at, what amount of your assets are you comfortable with gifting to the children directly or into a trust for the kids? That's what we'd be looking at primarily. There are some annuity products out there. I mean, you all would know the details on these that are what they call Medicaid qualified annuity.
Yeah.
Okay. Keep in mind, however, those products generally do have a requirement that the state gets named as a beneficiary to some degree on those. So that's not a magic bullet that's going to all of a sudden transform a person's financial picture from, millionaire to Medicaid eligible.
Yeah.
There's a lot of details that we'd have to discuss about what type of annuity makes sense to purchase in that situation. The other thing is, the question usually comes up of when should we start doing a spend down? When should we do that? We know what the accountable resources are going to be. We know what the community spouse resource allowance is going to be. We know what our spend down is going to be. When do we start doing that? And the answer is you generally don't do that until the person, the spouse, has been institutionalized. Okay? Because we need to take a snapshot of what are the assets worth at a certain point. So you need to know what are the assets of the husband and the wife as of the first date that the person was institutionalized. Sometimes that hasn't happened yet. They're still in the planning phase. They see maybe some months from now or years from now, they're going to have to go into a nursing home. In those scenarios, again, we're primarily looking at, what can be gifted? What can be gifted? Once the spend down button is sort of pushed, we know we've got a first date of institutionalization, we know our snapshot date, we know the value of the assets, then we can start pushing the buttons on, okay, spend some money on, again, what's the house look like?
Yeah.
Does
Because the house is a protected asset, right? Yeah.
protected assets, so you're converting countable resources into non-countable resources. Is there a mortgage that needs to be paid off on the house? That's an easy way to spend down money
Yeah.
on a non-countable asset. Is there a car loan that needs to be paid off? Do home improvements need to be made? If they're not, or do you want to buy a bigger house? Okay? Sell the current house, buy a more expensive house to do the spend down. Sell the current car, buy a bigger, more expensive car. I mean, it is permitted.
Yeah.
Maybe they don't want to sell that house. Can we make improvements to the house? Do we need to pay for a new roof for the house? New driveway, new furnace, new air conditioner? The big ticket items on house maintenance items.
Yeah.
Spend money on all that. Then you're also looking at, what about the funerals? Have those been prepaid? All right, now it's time to pull the trigger on buying those. The prepaid irrevocable funeral arrangements for the husband, for the wife. Cemetery lots for the husband, for the wife, for the kids. Medicaid rules permit you to purchase cemetery lots for the Medicaid applicants' children, by the way. Those are all exempt. So those are kind of the common things we start doing once we're in spend down mode. And again, don't forget, and this is where you and your experts come in at CFS, look at these Medicaid qualified annuities. They're out there. Sometimes they make sense to buy, sometimes they don't.
Yeah.
Okay?
Absolutely.
Yeah. So,
Also,
Is that-
what comes into play too is like when you're going to, if you're gonna pay off the house and things like that, just the tax designation of the assets as well, right? Is it pre-tax IRA assets? Is it post-tax or Roth IRA assets? Is it
Right.
just normal non-qualified taxable assets? And, you know, oftentimes when we work together with you and you're working with a family, you just give us kind of a flow sheet, right? And you say, hey, you know, I need your financial recommendation on this, but you'll be like, hey, these are the assets that I would think, you know, hey, go ahead and get these spent down first. A lot of times, we know this already now because we've been doing it for a long time, but you always include in there, hey, check the beneficiaries, because if the husband needs care, the wife needs to make sure that the husband's no longer a beneficiary, because God forbid something happens to the wife,
It's a very
we don't
common
need
thing.
the husband,
Correct.
inheriting a bunch of money in this situation.
That's right,
Um,
that's right.
And so it sounds to me like if you have this $1 million situation, you can do a lot to put resources into assets that aren't counted in terms of Medicaid, and then basically you're gonna get down to a certain level where that 50% rule is going to apply. And even if they spent stuff on those resources, they're probably gonna be above that 130 that we're just using as an example right now.
Right, right,
I said we'd throw the actual figure up on the screen.
okay.
So, really, basically, when you're talking about gifting, it's the difference between that 130 and whatever that half is left. That's basically, hey,
Right.
while keeping in mind though, you're gonna need to keep behind, if Medicaid has a 5-year look back, 5 years of resources to pay for that care while that's
If
taking
gifts,
place,
if gifts
right?
have been made, that's right,
Yeah.
that's right. Yeah, we're always looking at, you know, what if something happens if we're 2.5 years after the gift has been made? You know, then what? Well, do we have enough other assets remaining to privately pay?
Exactly,
So, yeah, we are kind of looking at, to be honest with you, and I'm always honest with you, but, does it make sense to gift any assets at all?
Yeah. Well, average
If-
stay in a nursing home, right, is 2 to 2.5 years. So, I mean, there's that aspect of it too.
Right. If the clients have got investable assets, say, over, just real big ballpark number,
Mhm.
500,000,
Mm-hmm.
then we say, look, what amount of this over the 500,000 are you comfortable with gifting? Gift that excess out, because it doesn't make sense if you've got less than 500,000. In a lot of cases, it does not make sense to do any gifting. All right, because of the risk that, 3 days after you've done this gifting, you got to go to the nursing home.
Yeah.
How you gonna pay for it?
Mm-hmm.
And you got to wait 5 years.
Yes, you
Well,
have to
you have
keep,
to have some money there to
Yeah.
privately pay.
you have to keep the reserves behind.
Right.
Yeah.
So we've got to take a very detailed look at what the client has, all their assets, what are they worth, how are they titled, and then pick and choose from the assets what makes sense to gift. The retirement accounts, the IRA accounts, 401ks are very typically the largest asset that the person owns, and those are the worst assets to gift out.
'Cause
You know,
that's bull-
You've got to withdraw the money
Yeah.
from the account to make the gift,
Mm-hmm.
and when you withdraw the money from an IRA or 401k, it's taxable income.
Yeah.
So very, very often, we're kind of stuck, because we
Mhm.
look at what everything the client has, and most of it's in IRA or 401k,
Yeah.
and we tell them, look, if you want to make a gift, it's great, start the 5-year time
Mhm.
clock ticking, but you're going to have to pay income taxes on the amount you're taking.
Mm-hmm.
They got it, very often they're over age 72 anyway, so there is a required minimum that they have to take, but this is beyond the minimum. So-
Yeah.
And very often the
So,
clients get heartburn when they hear that, hey, your taxes are gonna go up, income taxes are gonna
Yeah.
go up because you have to take this more from your
Yeah.
retirement account.
My father, Roger Ford, which you've been working with for many, many years.
Yes.
He has a famous saying, and I think it applies in this situation, is sometimes you have to pick the way you want to lose,
Mhm.
right?
Right.
And a lot of times when you get into a Medicaid spend down situation, you're picking the way you want to lose. On the one hand, you can allow Medicaid, you can spend down every single, dollar that you have, aside from the 130, but just, as a metaphor, you can spend down every dollar that you have and then wait for Medicaid to pick up the tabs, or you can take steps to protect some of your family's assets, make sure that there is some money that goes down to the next generation. But that also is going to mean that you potentially are going to incur a tax liability
Right.
because of that. So it's just, but it's basically on the one hand, you have protect some of the financial assets that
Right.
you have, or you don't and you spend it all down and then you qualify for Medicaid. And that's really kind of what we're talking about
Yeah.
here. And
What
on a
scares you,
broad
what scares
level,
you
right?
most?
Yeah.
What scares you most? An increased income tax burden or losing it all to the high cost of skilled nursing care because
Yeah.
you did nothing?
Yeah, exactly.
That's not a good choice to have, but those are really, very often, your two choices.
Well, I want to thank you so
Sure.
much for your time today. We're so excited to have you.
Thank you, Spencer,
Yeah.
absolutely.
On September 15th at
Sure.
our Pine Education Forum. And then so like, and just as kind of a teaser, we didn't talk about some things. We didn't go heavy into trust. We didn't talk about TOD designations on houses and things like that, which
Right.
is state specific. So don't, go out and do anything about that right now. So maybe
Right.
we'll get the opportunity to have another conversation in the future when we'll dive into
Would love
maybe
to.
some more more advanced
Sure.
estate planning stuff. But just because I want to give you the opportunity, you've been so gracious to us. Where can people find you? Where can people find Wood and Lamping?
Woodlamping.com is our website. Email me, edbender@woodlamping.com. Telephone number 513-852-6002.
Perfect. And you can find us at conservativefinancialsolutions.com, and you can also find the number on the screen, and we'll make sure your information gets up on the screen there too. So we've
Appreciate
been working
that.
with you for a long time. You take really good care of our families, and looking forward to a future relationship with Wood and Lamping and with you, Ed Bender. Thank you very much.
Thank you, Spencer.
Yeah, it was a pleasure.
Thank you.